A notice invoking arbitration under Section 21 is mandatory to fix the commencement date of arbitral proceedings, determine limitation periods, and establish applicable law. However, non-service of such notice on a party to the arbitration agreement does not preclude their impleadment in arbitral proceedings by the tribunal. The purpose of a Section 11 application is to appoint an arbitrator when the agreed procedure fails. The referral court's prima facie examination of the arbitration agreement's existence does not restrict the arbitral tribunal's jurisdiction to implead parties not referred in the Section 11 order. The tribunal's jurisdiction stems from the arbitration agreement under Section 7. Under Section 16, the tribunal can determine whether a non-signatory is a party to the agreement based on their conduct and consent as per the principles laid down in Cox and Kings v. SAP India Limited. Non-signatories were held to be parties to the arbitration agreement in Clause 40 of the LLP agreement due to their conduct in performing obligations under the agreement despite not being signatories. The tribunal erred in dismissing proceedings against them solely for lack of Section 21 notice and non-joinder in Section 11 proceedings. The arbitral tribunal must exercise its jurisdiction under Section 16 to examine whether a person is a party to the arbitration agreement, rather than relying solely on procedural grounds like non-service of notice or non-joinder in Section 11 application. The appellant and respondent number 1 formed a limited liability partnership under an agreement dated 1 June 2012 with an arbitration clause. Respondent number 3, the CEO of the LLP, was responsible for its administration. Disputes arose regarding the ITF project, leading to a Section 21 notice issued only to respondent number 1 and a Section 11 application impleading only respondent number 1. The High Court appointed an arbitrator, but the appellant later impleaded respondent numbers 2 and 3 in the statement of claim. The arbitral tribunal, under Section 16, held it lacked jurisdiction over respondent numbers 2 and 3 due to non-service of Section 21 notice and their non-joinder in Section 11 proceedings. The High Court upheld this under Section 37. The Supreme Court allowed the appeal, set aside the High Court's order dated 8 July 2024, and directed the arbitral tribunal to implead respondent numbers 2 and 3 as parties, finding them bound by the arbitration agreement due to their roles and conduct under the LLP agreement. The tribunal was directed to continue proceedings expeditiously.